Last matter coming before the court this morning is appellant Corry Sage versus City of Akron. Morning. Each party will have 15 minutes in which to present the case. The appellant may retain up to 5 minutes for rebuttal. If the appellant wishes to reserve that time, let me know when you come up to the podium. I'm keeping track of the clock and we'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have ready to briefs and we're ready to proceed.
Good morning. May it please the court, I'm Susan Manofsky. I work for the Legal Defender's Office of Summit County, and I'm here on behalf of the appellant, Corry Sage. Corry Sage was convicted in Akron Municipal Court of violating a civil protection order. The civil protection order had been granted to his estranged wife during the pendency of a divorce. As we all know, divorce cases can be the most contentious. And sometimes parties resort to abusing the legal system in order to get their way in a divorce, especially in a case such as the Sages, where there is custody at issue. The defense was not permitted to present their theory of the case at trial. And these issues were raised prior to trial by way of a motion in limine filed by the City of Akron. The first assignment of error before you addresses a preliminary matter that should have resolved this case without prosecution. Under the law as it existed in 2017, when Corry Sage was charged with violation of a civil protection order, it would have been required to prove that he was personally served the civil protection order. That's an onerous task, and it's one that the city did not meet. They did not meet their burden of proof, and the trial judge did not understand the law in existence at the time and refused to instruct the jury about proof of service. It is an onerous burden of proof, such that the Ohio legislature changed the law to relieve the prosecution of that burden. But at the time of Mr. Sage's trial, the city needed to prove that. That alone is reason to reverse the decision and enter a not guilty in favor of the appellant. Notwithstanding that, the defendant also attempted to argue mistake of fact, because this defendant was told by his divorce attorney that the civil protection order no longer existed. Whether or not he was personally served it, the defense is entitled to present as many defenses as he can, and they don't have to be consistent with one another.
A lot of case law that says mistake of fact is limited to specific intent. Crimes, this element here is recklessly.
I agree.
Your argument is that, well, your argument is?
Yes, and I agree there are cases that say that. The way Mr. Sage's case was prosecuted and instructed by the trial court made it a strict liability offense. That is not what the law allows. So this isn't like a charge of assault, or I think some of the better examples were drug trafficking, where the mistake of fact is as to the amount or the identity of the substance. In a violation of a civil protection order case, it's a special law. This law only applies to Corry Sage. So you cannot say that the recklessly element applies to his knowledge that there is a protection order, because that's not what the state of Ohio said in 2017. In 2017, he had to be personally served, not his attorney served, not left on his door, not mentioned by a judge. He had to have personal service of the document. That's not recklessly. That is specific. He has to have specific knowledge that these rules and these restrictions apply to him. The recklessly element goes to the subsequent conduct after he's been served. Does he engage in reckless conduct such that he's driving in her neighborhood, he's too close to where she works, or any of the other things that are prescribed in that protection order, such as drinking alcohol, which is often the case in a protection order, or possessing a firearm. There are many ways you can violate the civil protection order.
But your mistake of fact argument is that his attorney told him, hey, we had this hearing, she's agreed to drop the CPO, it's been lifted.
That's correct.
It's not a service argument, it's a,
Well, the service argument is my first argument.
Yeah,
That's
I
not.
understand that.
You're right, that's not the mistake of fact.
so are you arguing that he can't act with heedless indifference to the consequences if he believed the CPO was lifted?
Exactly. If he believes the CPO is lifted, then his conduct is no longer criminal. He wasn't even allowed to argue that. The judge essentially narrowed the issue to whether or not he left the restaurant fast enough when he became aware she was across the street. That's not fair. There's no possible reason for a trial judge to deny an instruction on personal service when it is essentially the gateway to even a prosecution, unless she made a mistake of law. She just didn't know. That's why we're asking the Court of Appeals to send this case back with correct instructions. I'll reserve, unless there's a question, I'll reserve my time.
Well, something, I've got a hearsay going through my mind as to what was the discussion between the attorney and the defendant. Would that be hearsay?
The attorney was there, so we proffered the attorney's testimony in the trial court.
So you tried to call the attorney?
We did.
And then you made a proffer?
And the trial judge refused to let the attorney testify, finding it was irrelevant because it went to mistake of
All right,
fact.
thank you.
Good morning, Your Honors. Ryan Bremer on behalf of the state of Ohio. This case obviously, on its face, seems pretty simple because it's a violation of a CPO case. What ended up getting argued in the briefs is much more in depth than what the number of assignments of error would actually indicate. There were 4 assignments of error. There were 3 of which were pretty straightforward. The 4th one was a cumulative assignment of error that raised the number of new assignments of error within it that weren't argued separately. So what ended up happening was there's about 13 assignments of error in this case. But I'm going to focus on the first three assignments of error. Excuse me. And those were about the jury instruction, about sufficiency of the evidence, and about the mistake of fact. The mistake of fact is not applicable in this case. The trial court correctly excluded it. The mens rea is reckless. It's whether you recklessly violated a CPO. It's not whether you knew the CPO existed. It's not whether you knew anything else about the terms of CPO. It's whether you recklessly violated the CPO's terms.
How about my question to opposing counsel? I mean, if he believed the CPO was lifted, how could he act with heedless indifference to the consequences? There'd be no consequence if it was lifted. If he believed it was lifted.
Well, if he believed it was lifted, that in itself would have been considered reckless. The court never issued a new decision. And quite frankly, the idea of the attorney proffering the testimony, the attorney came in, he did proffer testimony that he told Mr. Sage that despite the fact the court never issued an order lifting the CPO, despite the fact the CPO specifically said that the defendant could not give you permission to violate the CPO, that somehow the defendant had agreed to lift the CPO against him, which inherently is, quite frankly, I'm stunned that the member of the bar would say that. But on top of that, that testimony only goes to what the attorney would have, in theory, told him. Even assuming what you accept what the attorney said is true, that only goes to what maybe the attorney told Mr. Sage. Mr. Sage, by his own admission to the police officers and on the jailhouse call, indicates that he knew the CPO still existed. He says that. He says, like, when the officers come over and arrest him, he says, I thought I was 500 feet from her. He didn't say, oh, I didn't think it was still in effect. He said, I thought I was far enough away.
Well, couldn't that be that the officer's telling him you're in violation of the CPO? Maybe he knew that the original CPO that he believes has been lifted called for 500 feet.
Why would
And he says, well, I'm over 500 feet away anyway, even if it is an effector.
But you would say it's not an effect anymore. That would be your first argument isn't like technically I'm not violating it. It's technically it doesn't exist. Like that would be your first statement. And even when he talks about it on the jailhouse call subsequently, he says this has been in effect for nearly a year and I've never violated it previously.
But counsel, that seems like you're making a closing argument to the jury after they've heard two different contradictory statements as to the protection order. In other words, the attorney testifies, hey, I told him it was dropped. And then you get up and have your witnesses and then you argue to the jury, well, that doesn't make any sense. He still had to believe it was in effect because he did this, this, and this. But the judge here said this was irrelevant, not even be able to be admissible.
Well, it is irrelevant because the mistake of fact doesn't apply to this case. But furthermore, it doesn't have any probative value either because unless Mr. Sage testified that he actually thought that it wasn't in effect, that what the attorney told him does not go to whether he believed it or not. Because that is completely outside, that does not actually go to what his state of mind was. That's what someone else was indicating, a fact that he related to someone, but that does not actually indicate what that person's state of mind was at the time. And that's the issue, is it's not really relevant because it doesn't really it would not inform the jury about what Mr. Sage himself was actually thinking. Because it's not clear, it doesn't go to whether or not he actually knew the CPO was in effect or not. It just went to what his attorney had told him at some point months earlier.
So of course, I'm sorry.
No, you go right ahead.
The motion eliminated was a pretrial motion.
It was.
Granted.
Yes.
By the court, so Mr. Sage knew the attorney wasn't going to testify. Right?
Well, they let the attorney come in and proffer. So like the attorney, he knew at the time of the trial that the attorney was.
He knew the jury wasn't going to hear from the attorney.
Mm-hmm.
So
Then it's a different decision.
I was going to say, so what I think Judge Giudoso is, because I noticed this too, so you change your trial strategy. I'm not going to put my client on the witness stand whenever the attorney's not going to be able to preface it and make him look credible.
Well, again, it goes to the fact, it was correctly eliminated because it's irrelevant evidence and doesn't apply to the mistake of fact. This just goes to the fact on top of that, unless Mr. Sage testified, which there's no evidence that he was going to, that's not proper, that he would have testified but for this testimony being eliminated. That's pure speculation about whether or not he would have testified. And the fact is, what?
For both sides.
Yes, but I don't have to defend the speculation. Like, they have to, in order to prove reversible error, they have to actually demonstrate they had suffered some harm. Absent that proffer, they can't possibly suffer harm from this. Because unless he testified, he couldn't, the attorney's testimony is irrelevant to the case.
Okay. So I understand your argument about mistake of fact, but it still seems like there should be some basis that it's relevant, just like you have to be able to show that the defendant did know about the CPO, that he was either, at that time, was served with it, right?
That at the time of this case, the Supreme Court had stated that service was an element of it. The state legislature subsequently corrected the Supreme Court and said, no, we never intended this to be an element. And that went into
It's kind
effect.
of weird, anyway, that the legislature would tell the Supreme Court that notice was not an element. I think that's kind of like maybe a constitutional issue.
No, I mean, the General Assembly gets to decide what is and what is not an element of an offense. And the Supreme Court,
And the Supreme Court can say it's unconstitutional.
Correct, but the Supreme Court didn't say that. The Supreme Court interpreted what.
I just was thinking that when I was reading it, it was interesting.
Yeah, but what the Supreme Court did was it read an element into the offense, and the General Assembly subsequently said, we never intended that to be the element.
Right.
And so, like, basically, this idea of service, it was an element at the time, but the fact is, that was never an issue at trial. The idea of service never came up at trial. That was not part of the criminal rule 29 motion. They moved on different grounds, and therefore they forfeited any argument about the sufficiency of the service.
But didn't they argue for a jury instruction?
They did not. They gave a jury instruction to the court at one point. The court subsequently showed that was before trial. At trial, the court showed them a new jury instruction and said, do you have any objections? And they objected to the mistake of fact being left out. They did not object to the fact service wasn't in there. They forfeited all but plain error because they didn't object to it. And they have not actually argued plain error on appeal, because they have not argued how, but for this evidence, like this jury instruction being missing, the outcome of the trial would have been different.
I thought there was some case law that said it was sufficient to just submit the jury instructions to the court without renewing your objections. You're not aware of that?
I'm not aware of that, of that evidence.
I may be recollecting improperly, I'm just wondering.
They forfeited all the plain error up here because they didn't actually object on the basis that the service was not in there. And then they have not actually argued how, but for the service instruction not being in there, the outcome would have been different. And that's the thing that kind of is a through line in the brief, is they don't really articulate why what happened here was not sufficient for service. And to the extent that an argument would exist for that, that's really not this court's duty to create that for them. And frankly, it's unfair to the state to have the argument be created for it without a chance to respond. And what happened here is basically the jury heard the case. There's tons of evidence this guy knew what, Mr. Sage. Mr. Sage knew what was going on with the CPO. His attorney signed for the ex parte on behalf of Mr. Sage. So that's what there's a signature line that says he signed for it. And that's what he proffered up at trial. But more importantly, Mr. Sage then sat through a hearing about the CPO. Mr. Sage then knew about the CPO, like he knew the terms of the CPO enough to talk to the officers about it. And he also knew enough to talk about it on the phone at the jailhouse. So clearly Mr. Sage, the whole idea of this idea of someone being served with a CPO, it goes to whether or not they know, they have the opportunity to actually know the terms of the CPO. And Mr. Sage in this case knew the terms of the CPO, and I think that it's pretty clear that he had seen the CPO, and Mr. Sage had actually reviewed the CPO with his attorney.
Let's assume the defendant objected to the failure to instruct on the delivery, the service issue, and the hate. Assuming that they properly preserved that, don't you think it was error for a court not to instruct on an essential element of an offense?
This court has already ruled on that issue, and the answer was yes. It was like last year, September, they cited it in their brief. And they also cited for the idea that this is plain error, but that's actually the opposite of what that case held. That case was that it wasn't harmless error in that case, as opposed to it being actually going the opposite direction, actually being plain error. So, but yes, the court already said that.
It would affect the constitutional right, wouldn't it? The right to have the state prove each and every element of an offense beyond a reasonable doubt.
For the error?
Sure.
I believe that it would not necessarily affect the constitutional right, because it doesn't mean the state didn't prove the offense beyond a reasonable doubt. And that's what you'd have to actually demonstrate on appeal, is that the outcome of the trial would have been different if the instruction had been given. And that's what the plain error analysis is about, is that if you don't object to it, you still have to prove that it actually had an effect.
Understood.
And they have not actually made that argument on appeal. And so that I wanted to touch on, that was one of the big issues, I think, in this case, is the judge didn't refuse the instruction, the judge just didn't give it, and it wasn't objected to at the time when you could have corrected the error. And when you sit there and the judge specifically asks you, do you have any objection? and you say, no, I don't have any objection to these instructions that you're about to give, that's beyond, even if arguably submitting them previously would somehow preserve it otherwise, this is almost an induced error at that point. If the judge specifically says, do you have an objection? And you say, no, I don't have an objection. I don't know how, the judge doesn't have an opportunity to correct what's happening there, even if it's an omission by error, oversight as opposed to intentional. And the reality is, even though Mr. Sage wants to take the position that somehow this not giving the mistake of fact instruction turned it into a strict liability offense, that's not true. The jury was instructed that it was reckless violation. It's still a reckless intent crime. It's whether you recklessly violated the terms of the CPO. And in this case, Mr. Sage, and again, this also goes to the fact that on appeal, the arguments are completely different than what they were at trial. At trial, it was all about mistake of fact, about whether the CPO was still in effect, and also whether or not he knew that the victim in this case lived across the street from the restaurant where he was at. Those were the arguments below. Now on appeal for the first time, they really wanted to shift it to being about service, which again never came up at trial, and about the issue of whether or not, they still want to argue about whether or not the person, he knew that she was across the street from him. It's very clear though that even assuming that he didn't know that she lived at that address, although if you listen to the jailhouse call, it kind of sounds like he might have, but again, that's more speculation. In this case, it's very clear, if you listen to the evidence presented and view it in light most favorable to the state, which is under the Criminal Rule 29 motion, he knew, he called out to her, and he said something to her, and then he stayed at the restaurant long enough for her to go in the house, call the police come, speak with her for a few minutes, and then go across the street and talk to him. The officers testified they were there for about 10 to 15 minutes before they went and spoke to him across the street. So that he's required under the CPO to leave immediately if he happens upon her by happenstance. And so even assuming their position is true, that he didn't know that she lived there, it's still very true that he then, the evidence of this case, if you believe it, demonstrates that he saw her, said something to her, and then proceeded to stay there. And then when the police come out with they actually got a wheel measurement out, and it was 110 feet. This isn't like a borderline case. This guy was, Mr. Sage was well within 500 feet.
Well, it almost sounds like Mr. Sage believed the CPO was not in effect.
I would say that it sounds like Mr. Sage thought that he could get away with it because he didn't actually believe the CPO that she would call him on it. So for the reason I set forth, the state would ask you to overrule the assignments of error because the defendant has not fully articulated reasons to reverse and affirm the decision of the Akron Municipal Court. Thank you.
And now you have 5 minutes.
Thank you, Judge.
First of all, the issue of service was raised in proposed jury instructions that were filed prior to trial, ruled upon by the judge to the detriment of the defendant. The defendant did object to the court's jury instructions on page 152 of the transcript. At no time did Attorney Kodish say, yes, Judge, we accept these jury instructions. That was not the conversation on the record.
Was there a specific objection or a general objection?
He objected to the jury instructions and went on to specify mistake of fact.
Well, isn't that a problem?
No.
By specifying, doesn't he waive other objections?
Absolutely not. These were filed in writing prior to trial. These aren't things that came up during trial that needed to be brought to the court's attention. It was brought to the court's attention at length. She exhausted her belief of what the law was and ruled accordingly before the trial began so that the defendant knew what the issues would and wouldn't be allowed to be raised.
Well, then did he renew his prior objections?
He renewed his objection for, are you talking about the jury instructions?
Yeah.
Yeah. Page 152 of the transcript is when he renewed the objection. I'm sorry, I made a few notes. The arguments of the appellee are really arguments as to why the law should be changed in respect to civil protection orders when he's talking about recklessly. And I'm not here today to dispute why or why the legislature should not have been able to change that law. And this is not a 2018 case, and we're not attacking the current state of the law. The fact of the matter is, in 2017, proof of personal service was required. The fact that the state legislature changed the law simply underscores how important that element is, and how plain that error is, and how prejudicial this case was. The motion in limine was granted prior to the trial. So Mr. Sage's counsel knew the jury was not going to get to hear from Attorney Scribner. He's not required to put his client on the witness stand, especially when he knows Mr. Scribner's not going to get to testify to the jury. In fact, if the city wants to rely on Attorney Scribner to suggest to you that Mr. Sage knew there was a civil protection order and that somehow service had been proven, which it's not, but if they want to rely on that, shouldn't they also have to allow the defendant to rely on Mr. Scribner to tell him there is not a protection order?
Of course, he appeared at the hearing,
Who appeared? Mr. Sage?
at
Sure.
the CPO hearing.
That still doesn't prove he had proof of service. Personal service is an animal unto itself, which is why the state legislature changed the law. And I disagree with counsel respectfully, but if you look at page 37 of the transcript, the court refused to allow the questioning, the cross-examination of the officer on defendant's belief as to the CPO. Attorney Kodish asked the officer on the witness stand, "What's on the police report? Isn't it true that he said to you that he thought the CPO was lifted?" Prosecution objected, asked that it was stricken, and pointed out that's within what we're talking in regards to what was already ruled by the court. And the judge sustained the city's objection and ordered the jury to disregard. Thank you for your attention.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as